because as we know, the question is there this dealing requirement? And what's very clear from page 173 is that the argument that was being advanced on behalf of the claimant there was that there was an interference with a right that was sufficiently recognised by the law, that is, a right to carry on one's trade, that even in the absence of a contract between the shipwrights and the shipbuilders, an interference with their rights to carry on their trade was an interference with the rights which was sufficiently well protected to justify making the representative of the trade union liable for having effectively got the ship builders to discontinue the shipwrights engagement. And if we look at 173, that's the argument that is outlined. A violation of the right which every man has to pursue a lawful trade and calling. And then in the middle of the page, Lord Davy says this, but is there any such general cause of action irrespective of the means employed or mode of interference? I think it's unnecessary to comment on all the cases which have been cited by counsel and are referred to by the learned judges. I've read them carefully, and I'm satisfied that in none of them was anything decided which is an authority for the abstract proposition maintained. In every one of them you find that there was either violence or the threat of violence, obstruction of the highway or the access to the plaintiff's premises, nuisance, or other unlawful acts done to the damage of the plaintiff. Nor does it appear to me that the gist of the action in those cases was that the plaintiff was a trader or exercised a profitable calling. That circumstance, no doubt, afforded evidence of the damage. But I suppose that if a person obstructed the access to my house or to my vessel by molesting and firing guns at persons resorting thither on their lawful occasions, I may have my action against him, though I don't keep a school or I'm not a trader, but sailing in my yacht for my own pleasure. Or if a person obstructs my free use of the highway and I suffer damage thereby, I have a right of action, though my carriage does not ply for hire, but is used only for my own purposes. So what is helpful from that perspective is that what his lordship is saying is that what defines the tort is the unlawfulness of the action by the defendant as against the third party, resulting in damage to the claimant. And he specifically says, it doesn't matter if I'm not even a trader. It is not a tort that is confined to the factual circumstances of competitive trade, and it is not a tort which is confined to acts by a defendant which interfere with the third party's freedom to deal with the plaintiff.
But I don't quite understand where this is getting to. I mean, I thought that in your skeleton argument you were saying that OBJ is restricted to dealing cases.
We do say that.
Right, well, Allen and Flood is a dealing case.
Yes,
so they're both dealing cases. So how does it help you to say, how does it help you to say that Lord Davy in the dealing case didn't seem to think that dealing was necessary? Because we now know it is necessary.
Well, my Lord, the one thing, we will need to approach what OBG says, and indeed how we put it in our skeleton, carefully. What I want to understand first is exactly what the earlier case law does say, because ultimately what we will be saying is that, in a sense, you don't have to decide whether the dealing requirement is limited to dealing cases or to a subset of dealing cases, such as the licence cases, Pollard and so on. That all you have to decide is that there is no general requirement for dealing in order for the tort to apply.
I understand that. I understand that, but I thought you were referring us to Lord Davy in this dealing case, which is Allen and Flood, for the proposition that dealing isn't essential. But we know that can't be right in his case, because dealing is essential in a dealing interference with a third party. With those relationships between the third party and the plaintiff are critical in a dealing case.
Well, my Lord, as I say, what is said, I want to come to paragraph 51 of OBG and Allen with these cases in mind to see exactly what that assertion in paragraph 51 of OBG and Allen was in fact intended to apply to. Your Lordship may be right, and I think we do concede in our skeleton that the dealing requirement is a requirement in dealing cases, but it may in fact be narrower than that. The dealing requirement may in fact only be, so to speak, a description of why the elements of the tort are not made out in cases such as RCA and Pollard and the licensing cases. But what I want to do is to get to OBG and Allen with your Lordship's, with a clear understanding of what the case law thus far had decided, because one of the questions is what does OBG and Allen actually say, so to speak. But secondly, in my final point, in my fifth heading, is going to be the question of what ratio can you get out of OBG and Allen that is in fact binding on this court, because it is perfectly possible that their lordships said things which appear to be of general import, but which are not in fact part of the ratio. Now that may be a better or less good argument, depending on what the previous case law has already decided. So I do want to get to OBG and Allen with your Lordship's understanding what had been decided at the highest level before then. So what I take from Allen and Flood is that at this stage there plainly was not any dealing requirement, and indeed it didn't form part of the definition of the tort. And that is important when we look at what is said in OBG and Allen about the scope of the tort that was being endorsed in that case. The next case is Quinn and Leatham, 3 years later, which is in the second authorities bundle at tab 15. And this was another trades union case. It was a claim against members, this time rather than the representative members of the trades union, for causing a butcher to stop buying meat from a flesher who didn't employ union men. We can just pick up Lord Halsbury again as the first speech on page 505. And if we just look quickly at 506, about just over a third of the way down the page, there's a line beginning with the word now. Now, before discussing the case of Allen and Flood and what was decided therein, there are two observations of a general character which I wish to make. One is to repeat what I very often said before, that every judgment must be read as applicable to the particular facts proved or assumed to be proved, since the generality of the expressions which may be found there are not intended to be...
I have them now, at the bottom of page 506, now...
Top, sorry, about a third of the way down.
Oh, I see. Now before discussing the case...
Now, yes, sorry, yes. Before discussing the case of Allen and Flood, what was decided therein, there are two observations of a general character which I wish to make, and one is to repeat what I very often said before, that every judgment must be read as applicable to the particular facts proved or assumed to be proved, since the generality of the expressions which may be found there are not intended to be expositions of the whole law, but governed and qualified by the particular facts of the case in which such expressions are to be found. The other is that a case is only authority for what it actually decides. I entirely deny that it can be quoted for a proposition that may seem to follow logically from it. Such a mode of reasoning assumes that the law is necessarily a logical code, whereas every lawyer must acknowledge that the law is not always logical at all. And then if we go on to 532, with the speech of Lord Lindley, so he engages with Allen and Flood, and on 533 he says the decision, as I understand it, establishes two propositions. One, a far-reaching and extremely important proposition of law, and the other, a comparatively unimportant proposition of mixed law and fact, useful as a guide, but of very different character from the first. The first and important proposition is that an act otherwise lawful, although harmful, does not become actionable by being done maliciously in the sense of proceeding from a bad motive. And he says that wasn't new, but that clearly reasserted by Allen and Flood. And then at the bottom of the page, he says the second proposition is that what Allen did infringe is that what Allen did infringed no right of the plaintiffs, even though he had acted maliciously and with a view to injure them. And then over the page, he goes on to consider the facts of the case, and about halfway down there's number 1, as the plaintiff's rights. He had the ordinary rights of a British subject. He was at liberty to earn his own living in his own way, provided he did not violate some special law prohibiting him from doing so, and provided he did not infringe the rights of other people. So again, just pausing there, what is being debated in these two cases is the nature of the right that is said to be infringed on the part of the plaintiff. The analysis is not proceeding by reference to any discussion of an interference with a freedom on the part of the third party to deal with the plaintiff. The analysis is always, what are the plaintiff's rights? And then it goes on to say, and it would perhaps, you see from the previous paragraph where he says, I will now pass to the facts of the case and consider 1, what the plaintiff's rights were, 2, what the defendant's conduct was, 3, whether that conduct infringed the plaintiff's rights. So that's the analytical framework. And he then goes on in 1 to consider what the rights were, and he then uses these words after the passage I just read. This liberty involved a liberty to deal with other persons who were willing to deal with him. This liberty is a right recognized by law. Its co-relative is the general duty of every one not to prevent the free exercise of this liberty, except so far as his own liberty of action may justify him in doing so. Now, in talking about the freedom of trade, including a liberty to deal with other persons, his lordship was not defining the tort in any general codification sense. He wasn't saying the tort is only committed if there is an interference with freedom to deal. All he was doing was describing on the facts of that particular case the right which the plaintiff was saying happened to have been interfered with. This is not a general statement of law that the tort of causing loss by unlawful means can only occur where there is an interference with the right to deal, well, freedom to deal. He is simply describing, as he says, what the plaintiff's rights in that particular case were, about which there was a complaint of interference. So you cannot take, as my learned friends would wish to do, the passage talking about the liberty to deal being a liberty recognised by law, as if it was a general statement of law that defines this tort. It doesn't. It simply happens to be a description of the right that was infringed in this case.
This is the paragraph Lord Hoffman thought was so important.
Yes, it is. Indeed it is. And the whole thing is sidelined. I won't read the whole thing, but could I just also draw your attention on the next page, 535, where he says, right in the middle of 535, if the above reasoning is correct, Lumley and Guy was rightly decided. Whether he meant to refer to Lumley and Guy is another matter, because of course that was inducing breach of contract. As I'm of opinion, it clearly was. Further, the principle involved in it cannot be confined to inducements to break contracts of service, or indeed to inducements to break any contracts. The principle which underlies the decision reaches all wrongful acts done intentionally to damage a particular individual and actually damaging him. And that is a statement of principle. That's not a comment on the facts of the case. It is a statement of principle, and it is reflected, as we will see, in OBG and Allen, in paragraph 47 of Lord Hoffman's speech. That is the principle. That defines the tort. yes, it may well be illustrated by cases in which there is an interference with dealing in commercial competition cases. But those 2-3 lines actually define what the tort is. Can we move on to National Phonograph?
What did the other judges say?
Lord, there is...
That's just one speech.
No, there isn't. So just so you have it, page 505 is Lord Halsbury. We've seen some of that. Page 508 is Lord Macnaghten. Page 512 is Lord Shand.
I mean, they all agree with what Lord Lindley says here.
None of them disagree. Lord, I wasn't going to take you to other passages. I don't think many of the other speeches. There's Lord Brampton at 515 and Lord Robertson at 532, just before Lord Lindley.
Are you saying Lord Hoffman didn't understand Lord Lindley correctly? I'm not quite sure.
My Lord, I'm saying that when you get to the final questions, I mean, ultimately what you have to do in our submission is really two things in this case. One is to decide what the words on the page in OBG and Allen do mean. And the second is to decide which bits of the words on the page actually constitute ratio that is binding on this court. Now, in order to understand what is ratio, part of the exercise is to analyse what in fact the law appeared to be up to the point where the decision in OBG and Allen is made. And since OBG and Allen expressly says that nothing had been cited to the House of Lords in OBG and Allen that extended the tort beyond the limits described in Allen and Flood and Quinn and Leatham, we've got to see what those limits are in order to understand what the House of Lords in OBG and Allen was accepting were the proper limits. And so, for that reason, we do need to recognise that in neither of the defining cases, which Lord Hoffman subsequently describes, as I say, as being describing the frontiers of the tort, in neither of those is there even any discussion of a requirement on the part of a plaintiff to prove that the defendant had caused the third party, that had caused an interference with the third party's freedom to deal with the plaintiff. It just isn't part of the rationale of those early decisions. So that is particularly relevant in working out what the ratio in OBG and Allen is. It's particularly relevant in working out the significance of the Lunro and Fire decision, which is expressly covered in OBG and Allen and not disapproved. So, Lord, can I just very quickly deal with a couple of other cases before we get on to Lunro and Fayed. So there's the National Phonograph case and Edison Bell, which is in the Second Authorities bundle, same bundle at tab 11. Shortly, what the facts of this case, you understand very briefly, were that the plaintiff sold both record players or phonographs and records to wholesalers. And in order to protect their sale of records, what they did was they got the wholesalers to agree that they wouldn't sell to retailers, wouldn't sell their phonographs to retailers if the retailers sold competitors' records. So the plaintiff had a sort of blacklist of retailers to whom their wholesalers were not allowed to sell. The defendant was on the blacklist. The defendant wanted to get hold of the plaintiff's phonographs, and they adopted two stratagems in order to achieve that result. The first was they got one of their employees simply to buy record players from a retailer at the correct price, and the retailer got them from the wholesaler so there was no loss to the plaintiff. But the second stratagem, which is the one that is worth noting, the second stratagem is that what the defendant did was they got two of their own employees to buy phonographs directly from a wholesaler by lying to the wholesaler, by pretending that they were not working for a blacklisted purchaser. So the short situation there is the defendant is the purchaser, the wholesaler is the third party who is deceived, and the plaintiff is the one who is claiming to have suffered some loss. And the significance of the difference, as I say, is that in relation to the first transaction, where there was a purchase from a retailer, there was no unlawfulness because the retailer didn't have a contract with the plaintiff, so he wasn't acting in breach. And the wholesaler who sold to the retailers didn't know that the retailer was then going to make an onward sale to the defendant. So there was no unlawfulness there. But in relation to the second transaction, where the defendant's employees buy directly from the wholesaler by lying, saying that they were not employed by the blacklisted defendant, there was a deceit of a third party, the wholesaler, and as a result, the court either held or assumed that the plaintiff suffered loss because the plaintiff ended up having its record players being sold by somebody who was selling competitors' records. So, in relation to that second transaction, what we have is a deception practiced on a third party, the wholesaler, and a loss to the plaintiff, and a successful claim by the plaintiff, but again, no interference with the third party's freedom to deal with the plaintiff. The third party is the wholesaler. He's done nothing wrong. He's not had his contract with the plaintiff in any way interrupted. He's not had his ability to trade with the plaintiff in any way interrupted. Indeed, he's done nothing wrong in breach of his contract with the plaintiff, but the claim succeeds. So again, it is an illustration, and again, because it is mentioned with apparent approval in OBG and Allen, it is important to see that it is another case in which the court upholds a claim for causing loss by unlawful means without any interference with the third party's freedom to deal with the plaintiff. And we just very quickly take you through the case to illustrate that. So we have, if you've got tab 11 open, the judgment of the court starts at page 355. There are some sideline passages which I'm not stressing you don't read, but if I could just take you to a couple of passages to emphasize them, and some which aren't sidelined. So if we pick it up at page 360, where having cited Allen and Flood and Quinn and Leatham, in the middle of 360, Lord Justice Buckley says, I proceed then to apply the words of Lord Watson and Lord Macnaghten to the facts of this case. These defendants, knowingly and for their own ends, induced the factor, that's the wholesaler, to sell to them contrary to the duty which the factor owed to the plaintiffs. The factor was deceived, and for that reason an action for breach of contract may not lie against him. That is an action breach of contract by the plaintiff against the wholesaler. He acted innocently and did not voluntarily commit any breach of his contract. In my judgment, this doesn't differentiate the present case in the respondent's favour from the first proposition found in Lord Watson's words. The defendant company is in no better case because the wrong to the plaintiffs, which in fact was done, was by reason of the defendant's deceit done innocently, so far as the factor was concerned. Again, if this is not so well founded, then in my judgment, Lord Watson's second proposition at any rate applies, assuming that the act induced was within the right of the factor in the sense that he, being innocent, did not know wrong, and was therefore not wrongful so far as the factor was concerned, yet it was to the detriment of a third party, namely the plaintiffs. In that case, says Lord Watson, the inducer, that is the defendants, may be held liable if the defendants can be shown to have procured their object by the use of illegal means directed against the plaintiffs. The deceit which the defendants practice brings them, I think, exactly within these words. The act which the defendants did was, I think, a violation of a legal right of the plaintiffs because it interfered with the contractual relations subsisting between the plaintiffs and their factors, and there was no sufficient justification for such interference.
This wasn't simply just an inducement of breach of contract case.
No, there was no breach of contract, because the wholesaler who did the selling didn't act in breach of his contract with the with the manufacturer of the phonographs. So, Lord, that, and if we can just pick it up again, 368. So Hughes and Leach were the two employees of the defendant who told the lie to the wholesalers. If we pick it up at 368, the case made out by the plaintiffs in regard to Hughes and Leach transaction appears to me to differ in important respects from the L transaction. That was the purchase from the retailer. By intentional misrepresentation, the defendant company, through their agents or servants, procured from the factors goods of the plaintiff's manufacture, which the factors would not have parted with if they'd known that the persons with whom they were dealing were agents or servants of a firm included in the suspended list. There has been, in a sense, a sale, contrary to the terms of the intention of the factors agreement. Then comes the question, did such a transaction constitute on the part of the factors, in each case, an actionable violation of their contract? I don't think it did. The factors did not know or have reason to suppose that they were selling to the defendants, and on the contrary, they were intentionally misled by Hughes and Leach into the belief that they were selling to independent retail dealers. The names given by Hughes and Leach, not names on the suspended list, seems to me that a sale honestly made by a factor under these circumstances ought not, according to the proper interpretation of the agreement, be held to be a sale to a person on the suspended list, and as such constituting a breach of the agreement. So there was no interference in the freedom of the
breach
whole.
would have been knowing sales by the factor.
Yeah.
So there must be an implied term. They're saying in the factor agreement, saying that they shouldn't knowingly sell.
No
It's
doubt.
an implied
Yes.
term.
Yes. Yes.
Right.
Well, the whole of really the next 2 pages are sidelined, and could I just perhaps invite your lordships to continue the sidelining down to the very bottom, page 369. I don't propose to read all that, but again, in our submission, it provides an important analysis because it is a case in which there is clearly a cause of action upheld without any interference with the freedom of the third party, the wholesaler, to deal with the plaintiff. Same in a much shorter case of GWK and Dunlop, which is in the other authorities bundle at tab 7. The facts here, very simple, GWK...
By which
Sorry, bundle 1, tab 7. GWK was a British car manufacturer, long since disappeared, and Associated Rubber was a tyre manufacturer. GWK made cars, and they had an agreement with Associated Rubber that GWK cars would always be exhibited for sale and at motor shows with Associated Rubber tyres. There was going to be a car show, I think, in Birmingham. One of GWK's cars was going to be exhibited there, and showing tremendous initiative, Dunlop sent some men who simply took the Associated Rubber tyres off and put Dunlop tyres on. So the car was exhibited on the first day of the motor show with Dunlop tyres. Both GWK and Associated Rubber sued. Now, for our purposes of a three-party tort, it's the claim by Associated Rubber that matters, because what happened was a trespass to GWK's car. So GWK, for these purposes, is the third party. Dunlop commits a trespass to GWK's car, intending to and causing loss to Associated Rubber, because Associated Rubber's tyres are not then exhibited at the motor show, so they lose whatever you lose, goodwill, publicity. that act by the defendant did not, in any trading sense, interfere with GWK's freedom to deal with Associated Rubber. They were perfectly entitled to and able to enter into their tied agreement that Associated Rubber tyres would always appear on GWK cars, but the act done did in fact cause damage, and the claim succeeded, and Associated Rubber recovered very substantial damages as a result. The passage, the relevant passages are really on, it's the second page of the report, starting 2/3 of the way down the left-hand column. I don't think I need to read it to you. The relevant passages are sidelined, although frankly the whole of the report from the beginning, the very first sideline with regard to the law, down to the end of the judgment is worth reviewing. We cite it to you again as a case which is reviewed in OBG and Allen with apparent approval, but as clearly illustrating that the law did not, in that case, require any interference with the freedom of GWK, the third party, to deal with the plaintiff, Associated Rubber. And then finally, before we get to Lundra and Fayed, there's the case of Barretts and Baird, which is a same bundle, tab 3. And we're back to trade union activity here rather than competitor activity. The position in this case was that the Meat and Livestock Commission is employing what are called fat stock officers who work at abattoirs in order to perform various functions there. The fat stock officers union had a dispute with the Meat and Livestock Commission, and they called out the fat stock officers on strike. The loss was suffered by the abattoirs, who did not employ the fat stock officers, but they were the ones who suffered the loss as a result of the strikes. And so the abattoir owners sought an injunction against the trades union, the defendant, in respect of procuring the fat stock officers to go on strike and causing loss. No injunction was granted because on the facts of the case, the plaintiff failed to prove any unlawfulness on the part of the trades union in terms, any unlawfulness in terms of the Meat and Livestock Commission acting in breach of statutory duty. But there was held to be an arguable case of unlawfulness based on the breach by the fat stock officers of their contracts of employment with the Meat and Livestock Commission. But the plaintiffs didn't get their injunction because they failed to prove the necessary intention to injure, which is one of the other elements in the tort. And the only passage that I need to draw to your attention is on the fourth page of the report, paragraph 28. Because again, we get a clear definition of the tort without any reference to a dealing requirement. I come then to the first tort, interference with the plaintiff's trade or business, including his contractual relation.
This on the first page?
Third page, paragraph 28. Fourth page, sorry, 1, 2, 3, 4. Oh,
Yes,
fourth page, paragraph 28. I come then to the first tort, interference with the plaintiff's trade or business, including his contractual relations with his employees by unlawful means. This is now a clearly recognised tort. The basic ingredients are that that tort are common ground. First, there should be interference with the plaintiff's trade or business. There clearly is such interference here. Secondly, that should be the unlawful means. That is in issue in this case. Thirdly, that should be with the intention to injure the plaintiffs. That too is an issue in this case. And fourthly, that the action should in fact injure him. It's common ground that the plaintiffs have been injured by the fat stock officer's action in this case. So we get a short, succinct description of the tort without any reference any need to prove that there was an interference in the third party's freedom to deal with the plaintiff. Now, with those...
Does that help if it's a first instance decision with Justice Henry? Does that really help us at all?
It helps you to see, as I say, what the state of the law was that was being considered and whether or not, if OBG and Allen meant to say that, if it meant to say that there is a dealing requirement in all cases involving the tort of causing loss by unlawful means. One of the things I will be saying at my wrap-up at the very end is that any such suggestion is unprincipled and is inconsistent with the way the tort has previously been understood throughout. And that may lead you to the conclusion that that is not in fact what the House of Lords intended to say. If the House of Lords were merely repeating clearly long-established case law, reiterating a point that was beyond argument, that would be one thing. But we are arguing, as you'll see when we get to OBG and Allen, we are arguing about the significance of one sentence in the speech of Lord Hoffman, which is sandwiched between two other paragraphs which appear to say something different. And it's the sandwich, the bread on the sandwich, which I would invite you to prefer. You will be seeing paragraphs 47, 51 and 61. 51, second sentence, is the only place where this supposed need to establish an interference with the third party's freedom to deal actually appears. The tort is fully defined in para 47 in a way very similar to the way we saw it defined by Lord Davey in Quinn and Leatham, and that's repeated in para 61. So what I'm trying to build up is a little bit of momentum to show that when the matter does get to the House of Lords and OBG and Allen, nobody has previously suggested that this dealing requirement exists. It comes from nowhere, if it comes at all. So what I want to get your lordships' heads in the right place of recognising that their lordships cannot, with respect, have intended to introduce an entirely novel, entirely arbitrary concept without any policy rationale or discussion, and say this is now the straitjacket within which the tort exists in all factual situations.
You have a broader definition, I think, you're coming to than appeared to me in your skeleton arguments. There are the dealing cases and the public authority cases.
Indeed.
And I think you're punting now, I'm going to put it in the colloquialism, for a rather wider ambit of the tort than those two categories. Is that right? Have I got that?
Well, we would certainly not suggest, yes, and yes it is, we are not suggesting that the tort is confined to any finite factual situations. It's not a sort of binary case of competition law and public law cases. The tort is the tort. It's defined by the elements of an unlawful act by the defendant against a third party with intention to cause injury to the claimant and causing injury to the claimant. That's what the tort is. It's not defined by the facts of a competition case involving interfering with freedom to deal. It's not defined by reference to deceiving public authorities. Those are merely illustrations, factual illustrations of where the tort happens to have been found to succeed so far, or at least to have survived a strikeout so far.
And you would say that if the judge is right in his interpretation of OBG and Allen, Mr. Justice Henry has omitted an essential ingredient.
Exactly so.
Yes.
So can we then now look at Lunro and Fayed? And I'm sure the facts, so this is going to be same bundle, tab 9. The facts, I imagine, are well known to you. This was part of the long-running war between Tiny Rowland and Mohammed al-Fayed and his brothers about the taking over Harrods. What was alleged on behalf of Lunro was that the Fayed camp had lied to the Secretary of State in order to deceive him into not making a reference to the then Monopolies and Mergers Commission, and that had injured Lunro because it had precluded them, for various other regulatory reasons, it had precluded them from making a bid for House of Fraser. And so the factual situation there is that the third party is a public authority, the Secretary of State. The injury is an injury suffered by the plaintiff, entirely unconnected with any dealing, commercial dealing or anything else between the claimant, Lunro, and the Secretary of State, the third party. But in our submission, the facts could hardly be clearer. It is a strikeout case. It doesn't say the claim succeeds. All it says is what I need to persuade you of, which is that it can't be said at a strikeout that the claim can't succeed. And that is precisely what the ruling in the Court of Appeal says. So if we start with the Court of Appeal and go straight in the report to page 486, judgment.
The lies were not, of course, just to the Secretary of State, were they?
No, that's...
They were to the Board of Directors.
True.
And so there's no doubt that there was an interference then with the trading of the directors of, was it the House of Fraser? So it's very difficult to see how any argument about whether there was interference with the Secretary of State's ability would have helped anybody at all anyway.
Well, it was not, Lord, speculating as to what might or might not have been argued, if the facts to be different, is always problematic. But all we would say is that in describing the tort that was found to be arguably actionable, the Court of Appeal accepted that the claim was founded on the basis of misrepresentations to, in that case, principally the public authority, and that there is no mention of any need to establish that the deceived party should have had its freedom to deal with the claimant in any way interfered with.
No mention, but also no argument that it was an essential part of the tort.
I'm sure that's right too, yes. But that in itself speaks volumes, particularly when you start seeing, when it gets to the House of Lords, I don't think there was a member of the Chancery Bar or the Commercial Bar at Silk level who wasn't involved in the case. It was an astonishing lineup. And if it is...
My point is, not only was there no argument about it, but there wouldn't have been any point in any such argument. Because since the lies were told to the directors as well, and undoubtedly there was interference there, the claim would have succeeded anyway.
No, I don't think that is right, with respect, my lord, because the problem that was caused to Lunro was that they were unable to make an offer. And they were unable to make an offer because they hadn't been released from undertakings, and they weren't released from the undertakings, it was said, because the matter had not been referred to the Monopolies and Mergers Commission. It was nothing to do with what the respondent, what the House of Fraser directors might or might not have done in face of an offer from Lunro. It was the fact that Lunro was unable to make the offer, and the Secretary of State refused to make a reference to the MMC in respect to the Fayed's offer. That was the vice. That was the wrong that was said. Well, that was the causative events, which were said to cause the loss.
The point taken in the respondent's notice in Lunro and Fayed.
Yes.
And how was it dealt with? You're taking us to the case. You could bear in mind that I'm quite interested to know how that first point in the respondent's notice was actually dealt with.
I'm grateful. So if we could look at 486 in Lord Justice Dillon's speech, and we'll pick it up there. There's quite a lot sidelined, and as I say, I'm not disparaging the bits I'm not reading. I just want to focus on what really matters. And he says, if we go between D and E on 486, I pass now to matters of fact alleged in the statement of claim which are strongly disputed. Fair to all defendants to emphasise that they're strongly disputed. It's said by Lunro in the statement of claim that the Secretary of State's decision not to refer the bid by Holdings to Holdings was the Fayed vehicle to the Monopolies and Mergers Commission was procured by fraud on the part of the Fayeds and Holdings and on the part of Climates and Mr. MacArthur on their behalf. The nature of the fraud by the Fayeds and Holdings is said to have been a complete misrepresentation of the commercial standing and worth of the Fayeds, including representations contrary to the fact that the Fyers had money from their own resources to pay for the share capital of the House of Fraser. It's not said that the nature of the representations was to run down Lunro, but to puff up the position of the Fyers, so that there would be no reference to the MMC of the bid by Holdings, or indeed of any bid by Holdings in the Fyers. It said that if the truth had been disclosed, there would probably have been a reference to the MMC, and the outcome would probably have been that the Fyers would have been barred from acquiring control of House of Fraser and would have been required to divest themselves of the 50% plus interest which they had acquired. If Lunro is right on the pleaded facts, it's obvious that there was a deliberate fraud on the Secretary of State, at least on the part of the Fyers. In justice of Kleinbutz and Mr. MacArthur, not said that they knew, it said that they had a duty to satisfy themselves if they failed recklessly. Accordingly, the trial of the action of Mr. MacArthur may be very different. And then he goes on to describe against those facts the various claims between C and D. You'll see there's a reference to a claim in negligence, and between D and E there's a reference to a claim in conspiracy. That couldn't succeed at Court of Appeal level because there wasn't there was then the Metal and Rostov decision, even in relation to lawful means conspiracy, required a predominant intention to injure, and that wasn't alleged. So conspiracy had to fail at Court of Appeal level, but was revived in the House of Lords. For our purposes, it's between G and H that we pick it up. The third cause of action alleged in the statement of claim is the common law tort of wrongful interference with trade or business. The existence of such a tort is conceded by the defendants. Reference is made to Mercer Island and so on, and then there's some discussion of various other cases. And then if we can pick it up again at 488, that letter G, submitted to us, even with this tort, it must, as with the tort of conspiracy, have been the predominant purpose of the tortfeasor to injure the victim, and that argument is disposed with. And then at 489A, it's also submitted for the defendants that for this tort of wrongful interference with business to apply, there must have been a complete tort as between the alleged wrongdoer and the third party against whom the wrong was practised, to the detriment of the plaintiff in the action. It's said that that is not the case here, because through fraud was practised, if the allegations of Lunro are correct, on the Secretary of State to achieve the end that the Secretary of State did not refer Holdings' bid to Monopolies and Mergers Commission. The tort of deceit requires that the plaintiff should have suffered damage, and the Secretary of State suffered, it is said, no actionable damage. I, for my part, can see no valid reason why the tort should need, as against the third party, to have been complete to the extent that the third party had himself suffered damage. The distinction drawn by Lord Diplock elsewhere between primary and secondary obligations may be relevant. Apart from that, the need to show that the injured party had suffered damage, as opposed to the plaintiff having suffered damage, the injured third party had suffered damage, as opposed to the plaintiff having suffered damage, was not a factor in the decision of the majority in National Phonograph and Edison Bell. It's also to be proved by a plaintiff who seeks to rely on this tort that the unlawful act was in some sense directed against the plaintiff or intended to harm the plaintiff. Origin of those phrases are in Allen and Flood and National Phonograph. I have to bear in mind, however, as I have endeavoured to bear in mind throughout the hearing of this appeal, that this court has before it not the trial of the action or an appeal from a decision of the judge at the trial of the action, but an appeal on a striking out application. The rule is well known, clearly stated. Only in plain and obvious cases that recourse should be had to the summary process. Summary remedy under this rule is only to be implied in plain and obvious cases, when the action is one which cannot succeed or is in some way an abuse. Furthermore, as Cousins Hardy pointed out in Dyson and the AG, the striking out procedure ought not to be applied to an action involving serious investigation of ancient law and questions of general importance. Here, the existence of this tort is recognised, the detailed limits of it have to be refined. And he says it is, he regards it as right and essential, right and essential, that this should be done on the actual facts as they emerge at the trial, rather than on a set of hypotheses, more or less wide in very comprehensive pleadings. And then to just pick it up again in Lord Justice Rafe Gibson's speech on page judgment on page 492, where his lordship said, C, has also contended that the unlawful means used by the Secretary of State must be itself demonstrably actionable as a complete cause, and that in this case that is not pleaded as an alleged fact, because it's not said that there was any financial loss suffered by the Secretary of State. For my part, I don't accept that fraudulent misrepresentations used to a public official in the circumstances alleged in this case cease to be unlawful means for the purposes of the tort of unlawful interference with business, because there is no identifiable financial loss caused, in addition to the fact that a public official has been caused to do by the fraud what otherwise he would not have done, or not do what otherwise he would have done. Now that is the decision of the Court of Appeal at the strikeout stage. It doesn't mean we win, but it proves in our submission that it cannot be said, if this case remains good law, it cannot be said that we are bound to fail. Those words in our submission are absolutely clear, and the case went to the House of Lords, both on the conspiracy point, where the House of Lords overturned Metal and Rostov and said you can have a lawful means conspiracy, an unlawful means conspiracy without a predominant intention to injure. But the case also went on the causing loss by unlawful means, and the Court of Appeal's judgment was upheld for the reasons it gave. We have the House of Lords at tab 10 in the same bundle. Lord Bridges' speech starts at page 461. 462, he discusses the two appeals that are in front of the court at 462G on conspiracy and on unlawful, causing loss by unlawful means. Over the page on 463, he deals with the conspiracy issue, which doesn't need to detain us. We go straight on to 468, letter H, at the bottom of the page, where he reaches his conclusion on conspiracy. And then at 469B, having expressed the conclusion on conspiracy, he then breaks and talks about the test on a strikeout, with which you will be familiar, but worth emphasising all that, and we get much of the same of what we got in the Court of Appeal. So that's 469 across to 470. And then at 470E, he says this: for these reasons, so applying the test for strikeout, and for the reasons given in the judgments of the Court of Appeal, I have reached the conclusion that it would be inappropriate to strike out the statement of claim, and that the case must accordingly proceed to trial. The House of Lords says, in terms, for the reasons given in the judgments of the Court of Appeal. Those judgments clearly, expressly recognise the arguable availability of the tort in circumstances where a public authority has been misled. And there is no requirement in that situation for there to have been any dealing between the public authority and the injured plaintiff. So we have reached the position where a strikeout on essentially exactly the point in our case has survived in the House of Lords once before. So the question for you is whether the Supreme Court in OBG and Allen overruled Lunro and Fired and without anticipating too much, we say it cannot possibly have overruled Lunro and Fired without saying so in terms, and indeed, on the contrary, citing Lunro and Fired with apparent approval. So could we now go to OBG and Allen? Which is in the other authorities bundle.
I may be moving a bit slow. I'm just trying to follow here. You laid particular emphasis, is this right, on in the Court of Appeal in Lonro, that they 492 letter C. You placed great weight on that.
Yeah.
And you say, as I understand it, you look at 470 of the House of Lords report and letter E in the Bridges speech. You were saying they were approving, in effect, what was said there.
Yes.
But I thought that OBG required there to be an actionable cause of action in relation by the third party.
Yes.
So
with one exception. OBG expressly acknowledges that there can still be a claim for causing loss by unlawful means in a situation where the wrong done to the third party would be actionable if the third party had suffered loss. The tort doesn't cease to be available simply because the third party has not suffered loss, and that is a public authority case. The public authority is deceived. That gives rise to an action in deceit, or would, if the public authority had suffered loss. But OBG and Allen expressly recognises that the tort is available, notwithstanding that loss has not been suffered by the public authority, by the third party.
yes, but that's not the analysis in 492 C to D. 492 simply says, it doesn't go into that. It simply doesn't have to be any financial loss. It doesn't have to say it has to be actionable. It's sufficient that it would be actionable. It doesn't deal with that situation at all. It simply says, well, there's no requirement for financial loss, full stop.
Yes. But, I mean, deceit is deceit, my lord. I mean, he wouldn't have then also to labour the point by saying deceit is itself actionable, or at least would be but for
All
the
I'm
absence of
saying
loss.
is that all I'm trying to drive at, I suppose, is that if you're saying, relying upon what Lord Bridge says at 470E as an endorsement of 492C to D, the point that was taken was a very narrow one. Simply says, well, it doesn't have to be financial loss, that's all.
Yes, but he is...
It's not a full statement of the analysis subsequently made in OBG.
my lord, what it is saying... Well, can I just step back
The
for one
argument
moment?
was, I assume the argument was, no, there can't be taught by unlawful means, as in long run appeal. There can't be, because the Secretary of State hasn't suffered anything.
He has been sued, he has been deceived, but he hasn't suffered loss, and for that reason...
And they say that's not a requirement.
They say that...
That's not a requirement.
Yeah, and OBG and Allen agrees with that.
It agrees with that up to a point. What I'm saying is it's a very narrow point there. It's a very narrow point that's being argued there, and it's.
But,
I mean, they don't really go into the issue further than that.
well, what they are expressly saying is that a case based on deceit of a public authority gives rise to an arguable claim for causing loss by unlawful means. It really couldn't be more certain than that. That is what was decided in Lunro and Fired.
Yeah.
The specific point that was taken is, yes, the public authority was deceived, but it couldn't sue because it hadn't suffered any loss, was an argument that was run and failed. But the anterior point is that a deceit of a public authority does give rise to the three-party situation required by the tort of causing loss by unlawful means. And inherent in that is an acknowledgement by the House of Lords that it is not a necessary requirement in all cases for the tort to involve an interference by the defendant in the third party's commercial dealings with the plaintiff. because the Secretary of State had no commercial dealings with Lunro.
And in Lonro at the Court of Appeal at 492, he goes on, doesn't he, to say there are a whole lot of other points. It says a comparatively new tort, nature of the intention
Yeah.
required,
Yeah.
whether it has to be directed,
Yeah.
a whole series of points,
Yes.
commercial advantage, nature, and he ends up by saying, well, the point is that you should only do so in a plain and obvious case.
Yes.
And he says, I'm not concerned to say the points raised are particularly obscure, but they may be of different application, etc., etc.
Yeah. All of that, and we say all of that in spades in our case. Because once you have gone through OBG and Allen, it will be apparent that this case, which is authority for the proposition that a deceit of a public authority does found an actionable, arguable claim, this case survives. You cannot, with the greatest respect to this court, reach the conclusion that Lunro and Fayed has been overruled. It would be astonishing if the Supreme Court, or a majority in the Supreme Court, in OBG and Allen, genuinely considered that Lunro and Fayed was wrong and didn't say so.
Yeah, but they may have taken the view, looking at the matter broadly, that as Lord Justice Ralph Gibson said, it's a new tort, as at that day. There are a whole lot of things to be worked out about it. And it was more appropriate that should be done only in a plain and obvious case once all the facts have been established.
Yeah, absolutely. It
Can't
may.
really be
It
any
may.
doubt, can there, that the law was quite uncertain, at the loose ends left and so on, and that the House of Lords in OBG and Allen did want to make the law clearer and indeed a bit more restrictive than some of the cases had said.
Well, that is true. That is absolutely true. That Lunro and Fayed says the law is still finding its feet. OBG and Allen is a step towards the law finding its feet. But that, with the greatest, and this really ties in with my very last point about what precedent actually involves. However elevated the members of the Supreme Court may be, and however many judges they lined up for the hearing, the fact is that the Supreme Court hearing in OBG and Allen is just a decision in relation to the three cases in hand. It is not a codification of the law generally for all purposes. And what you do, and that's why I read you that passage at the beginning of Quinn and Leatham, what you do have to decide is what is the ratio in OBG and Allen. What was necessary as a statement of law to be decided in OBG and Allen in order to dispose of the appeals that were in front of the court. And my first, and in a sense my main point on OBG and Allen is that none of those three cases involved the tort of causing loss by unlawful means in relation to a deceit practiced on a public authority. Now, whether it is right that public authority cases are in a sort of category...
I'm slightly confused here because I thought you'd accept what my lord had said, that actually in your oral presentation now you're not actually having a separate category.
No,
of public
I'm not.
cases. So I think you have to say in non-dealing cases.
Yes, I'm very happy to say that.
It's in all non-dealing cases,
Yes.
basically.
Yes, that's right.
I suppose you were saying that the public authority one is a sort of stark example outside the area of interference with dealing as
Yes.
such.
Yes, it is. It is.
Although your predecessors were, in the Skeleton argument, were putting it much more rigidly as being the two
Yes.
types of
Yes.
interference.
It may be sufficient simply to say that the public authority cases happen to be the two non-dealing, happen to be the only cases that are non-dealing, that happen to have arisen are public authority cases. That doesn't prove that there is a category called public authority cases.
Apart from the debate
necessarily.
about the status of the bailiff, is Lonro the only one we've got of
Yeah.
a public authority being diddled, as you would say?
Yeah.
Yes?
Yeah.
Okay. Thank you.
So can we then go to OBG and Allen, which is in tab 14 of the second bundle. And as will be apparent, it may be helpful just to sort of say before I get into the detail of it, a couple of preliminary points. The first is the one I've already made. Looking at the ratio, the point that we're arguing isn't being decided there, doesn't need to be decided, so it can't be part of the ratio. Secondly, when one is looking at what is said about this particular tort in these judgments, it's important to bear in mind what the real debate between the majority and the minority was about. Lord Hoffman for the majority and Lord Nichols for the minority were worrying over the question of what constitutes unlawful means for the purposes of causing loss by unlawful means. And they used, as often happens as arguments in cases develop, they used the shorthand of a wider and a narrower scope. What they meant is this, that Lord Hoffman considered that the control mechanism for keeping the tort under manageable, within a manageable scope. Lord Hoffman said that unlawful means requires the wrong done to the third party to be actionable by the third party, whereas Lord Nichols preferred a wider view of unlawful means and said it would include, for example, a criminal act. He said, why, Lord Nichols asks, could a defendant escape liability in this tort in circumstances where he'd done something not just civilly wrong, but criminally wrong? And Lord Hoffman's answer is, the tort the criminal law provides its own remedies, civil law provides its remedies, and the tort is confined to situations, the narrow scope, as he calls it, is confined to circumstances in which the wrong that is done by the defendant to the third party is actionable by the third party, or would be if the third party had suffered loss. Loss by the third party is not a necessary ingredient, even on Lord Hoffman's narrow interpretation. So, although it's very tempting, as the defendants have tried, to use these labels of narrow and broad as if they were somehow entirely unspecific adjectives, and that Lord Hoffman's judgment can be read as simply meaning you've got to do whatever you do to make it as restrictive an application as possible. They were talking about one very specific issue. It's the nature of the unlawfulness that must be proved. That is the narrow or the broad view. Is it any unlawful activity, including criminal breaches of regulatory regimes or whatever, which was the Nichols approach, or is it only unlawful acts which are actionable by the third party or would be if loss is suffered, which was the successful prevailing view of Lord Hoffman. So when you're looking at the judgments, that is the sense in which narrow and broad are being used. But the important thing in our submission is that not only were none of the three cases, in fact any one of them involved unlawful, causing loss by unlawful means, which was the Douglas and Hallow case. None of the cases, sorry, put it another way, there was no issue in the appeals as to whether even an element of commercial dealing between the third party and the claimant was a necessary feature of the tort in all cases at all. It simply wasn't.
Could you repeat that?
There was no issue. There was no issue in any of the cases.
Sorry, we're talking about the old cases? Or
No, sorry, in any of the three cases under appeal in OBG and Allen, because there were three heard concurrently. In none of those three cases was there any issue as to whether an element of commercial dealing between the claimant and the third party was a necessary feature of the tort in all cases. And so we say, a fortiori, there was no issue in OBG and Allen as to whether in all cases a claimant has to prove that the defendant's actions interfered with the third party's freedom to deal with the claimant, because the existence of such dealings were not even argued to be a necessary part of the tort in all circumstances.
So I thought that it, and maybe the skeleton arguments moved on in your oral submissions again, but I thought that it was accepted that that OBG was authority, at least that in a dealing case there had to be an interference, a requirement that there had to be an interference with the liberty of the third party with to deal with the plaintiff. I thought that was accepted. Is that not accepted?
Well, that certainly is what the skeleton says. Having looked more carefully at GWK and at National Phonograph, that and in light of the apparent approval given to those cases, the skeleton may be, in a sense, conceding too much. It doesn't matter.
Well, it does matter. I mean, at least we ought to know what the submissions are on each side about what is the ratio. Yes. I thought that it was accepted, but it sounds like it's no longer accepted. It was accepted by your side that, at least in dealing case, that the ratio was that in dealing cases there had to be an interference with the liberty of dealing. Is that no longer the case?
That is certainly what the skeleton says. We are offering to you, having, as I say, looked at National Phonograph and GWK and Barretts and Baird, we are offering to you an alternative reading of paragraph 51, which is that the dealing requirement, as it's been described, is simply a description of why it's quite difficult to. Can I just read you a couple of passages first and then explain what we say they mean? Can we just look at Hoffman at 47, sorry, no disrespect to him. Page 31 of the report. Para 47. The essence of the tort, therefore, appears to be a wrongful interference with the actions of a third party in which the claimant has an economic interest, and B, an intention thereby to cause loss to the claimant. That, in our submission, reflects how Lord Davy put it. That, in our submission, is a comprehensive definition, if you want a definition, of the tort.
What's the economic interest of the Patent Office?
No, the claimant.
The claimant. Oh, I see. The claimant.
It's the claimant. It's the Secretary of State has to have the economic. No, I know. It's.
My fault.
And if we look also at para 61 on page 35. At 61, he says, I would only add one footnote to this discussion of unlawful means in defining the tort of causing loss by unlawful means as a tort which requires interference with the actions of a third party in relation to the plaintiff. I do not intend to say anything about the question of whether a claimant who has been compelled by unlawful intimidation to act to his own detriment can sue for loss. Such a case of two-party intimidation raises altogether different issues. So in 47 and 61, Lord Hoffman defines the tort or expresses the essence of the tort without reference to a dealing requirement.
Right, so I take it then that solution is that we are to find in the first paragraph, the first sentence of paragraph 47, the ratio.
Yes.
That's your solution.
Exactly.
All right.
That's, if you want, if the House of Lords, the Supreme Court, was giving a definition, if it was assuming the role of legislator or the Law Commission and defining the tort, that's the definition. And since we are in the thick of it already, what you will then see, in going back to 47, is that immediately below the quote I just read to you, he goes to GWK and Dunlop. So, without any expression of disapproval, in 49, over the page, the point that I was foreshadowing with my Lord, the Master of the Rolls, 49, in my opinion, and subject to one qualification, acts against a third party count as unlawful means only if they are actionable by that third party. The qualification is that they will also be unlawful means if the only reason why they're not actionable is because the third party has suffered no loss. Now that saves the third party public authority situation. It may save others, but that means that our case does satisfy his test. He then goes on in that paragraph at D to talk about national phonograph, intentionally causing loss by fraudulently inducing a third party to act to the plaintiff's detriment without any reference to a need for interference between the third party and the plaintiff's commercial dealings. And we've seen that that is what National Phonograph decides. And then in 50, Lunro, arguably within the same principle. The plaintiff said that the defendant had intentionally caused it loss by making fraudulent statements to the directors of the company on which owned Harrods and to the Secretary of State for Trade and Industry, which induced the directors to accept his bid for Harrods and the Secretary of State not to refer the bid to the Monopolies Commission. The defendant was thereby able to gain control of Harrods to the detriment of the plaintiff who wanted to buy it instead. In the Court of Appeal, Lord Justice Dillon referred to National Phonograph case as authority for rejecting the argument that the means used to cause loss to the plaintiff could not be unlawful because neither the directors nor the Secretary of State had suffered any loss. That seems to me correct. The allegations were of fraudulent representations made to third parties which would have been actionable by them if they had suffered loss, but which were intended to induce the third parties to act in a way which caused loss to the plaintiff. The Court of Appeal therefore refused to strike out the claim as unarguable, and their decision was upheld by the House of Lords. Now, the defendant's argument in this appeal is that that paragraph carries the sense, entirely unstated, that Lord Hoffman considered Lunro and Fire to have been wrongly decided. And in our submission, they simply cannot get that with sufficient certainty for a strikeout. Maybe they're right, maybe, but that isn't the test in front of you. You can only uphold the strikeout with respect if you are satisfied that we are bound to be wrong, and Lord Hoffman was bound to have considered Lunro to be wrongly decided.
It's a pure point of law that we're dealing with, aren't we? So in Lonro, they thought that the decision should be dependent upon the actual facts and circumstances. It wouldn't be right to strike out. I'm not quite sure your point. I mean, either you're right or you're wrong. Either you're right or the other side are right about the point of law. What will be the point of this of us saying this should go to trial because it's unclear what the ratio is? We have to decide what the ratio is. Whatever the facts turn out to be is not going to affect that point.
Lord, that is with respect, and I do mean that is a bold statement. Judges often think that the facts don't matter, and repeatedly appellate courts have said, don't strike out unless it's absolutely clear.
What are the facts that might emerge? I mean, either the ratio is what you say it is, or the ratio is what the other side say it is. What facts are going to change whether your submission on the law is correct or theirs is? What are the facts that might determine
Well,
what the
I
actual ratio
can't
is?
think of any facts that are likely to change the analysis on the law. The question is not that. The question is the strikeout mechanism the right tool to deprive a claimant of a trial in circumstances where the answer is not clear? The very fact that we're having this debate, and we've just finished a paragraph citing Lunro with apparent approval, and the argument in front of you is that Lunro was in fact overruled by this very judgment, demonstrates that this is not a clear case. Strikeout is simply the wrong thing to be using in order to test this
Or is
issue.
it the wrong thing short of the Supreme Court?
Well,
Where they tell us what this debate means. Is that what you're saying? Because
there is a significant amount of money at stake and no doubt a long trial, and I suspect that whichever side is disappointed by your lordship's ruling may take it further. That may well be right. But what is very...
So, but what this submission comes to is that although it on the face of it appears to be, I don't think you're dissenting from this, the question of what is the ratio is a pure point of law. Nonetheless, if there is uncertainty, if there's any uncertainty as to what the answer to that point of law is, we should allow the matter to go to trial.
Yeah, absolutely. And the uncertainty persists. We now get to the one critical sentence, because having cited GWK, Lunro, and National Phonograph, all of which crudely support my position, paragraph 51 says this: unlawful means therefore consists. He is basing the predicate for his conclusion on the cases we have just looked at. Therefore is an important word in that sentence. He is endorsing the approach taken in the three cases we've just looked at.
where's your therefore, Mr. Crane?
Sorry, para 51. Unlawful means therefore consists of acts intended to cause loss to the claimant by interfering with the freedom of a third party in a way which is unlawful as against that third party and which is intended to cause loss to the claimant. If that paragraph ended with that full stop, we wouldn't be here. It is only the second sentence in that paragraph on which this whole argument hangs. It does not, in my opinion, include acts which may be unlawful against a third party, but which do not affect his freedom to deal with the claimant. It is that two-line sentence which has been elevated to a general statement of principle in relation to all cases involving a claim based on causing loss by unlawful means.
What I'm forgetting, Mr. Crane, you'll no doubt take us to it, is what the other of their lordship and her ladyship say in relation to this issue.
Yes.
And I can't remember, frankly,
No.
as to
Well,
what they add to this sentence in paragraph 51.
yes. They do repeat words to similar effect,
Yeah.
those are quoted. I think Lord Walker, Lord Brown, and Lady Hale all use words to similar effect, and we can certainly go to those. But what we wish to point out is really two things. One is the prequel to para 51 and the word therefore, all of which supports us. And then, and this is where, in a sense, the analysis I'm now offering orally offers a different approach from that potentially in the skeleton. The words which do not affect his freedom to deal with the claimant are introductory to the next couple of paragraphs dealing with RCA and Pollard, Isaac Oren and Redbox, and the Lunro and Shell cases, because he starts the next paragraph thus. So he's made the statement in the second sentence of para 51, talking about this requirement for affecting freedom to freedom to deal with the claimant. And he then goes to talk about the RCA and Pollard cases and the Isaac Oren and Red Box cases, which were cases, as you may recall, in which a complaint was brought by a licensee about the RCA and Pollard is the exclusive licensee of Elvis Presley Records, is trying to sue a bootlegger. The exclusive licensee simply has an agreement from the owner, the Elvis Presley or his estate. The license is simply an agreement by the estate. We're not going to license anybody else to sell Elvis Presley records. That's your exclusive license. It's an agreement by the owner of the copyright not to license anyone else. The bootlegger, by selling unlicensed recordings, may be doing a wrong against the copyright owner, RCA, but what their lordships are saying is that that wrong didn't interfere with RCA's ability, its freedom, to grant a license to the licensee. The licensee has his exclusive license from RCA. And so in licensee cases, the fact that a wrong is done to the copyright owner, so we're told, doesn't give rise to a cause of action by the suit of the licensee, because the licensee's only interest in the matter, so to speak, is a license granted by RCA, and that license hasn't been affected. So in that sense, that is an explanation for the licensee cases, because the wrong done by the bootlegger there doesn't affect RCA's freedom to deal with the claimant. It doesn't affect RCA's ability, willingness, enthusiasm, to grant an exclusive license to the licensee. That may be the explanation for that one sentence. Because then, sorry, I was just going to finish. Any other explanation is inconsistent with what has gone before and is completely unexplained. Where does this pop up from, having never appeared in the previous case law, including the case law he's just been discussing? It only makes sense, so to speak, by linking with the word thus at the beginning of 52 to explain that that is a description of why the second element, sorry, the first element in para 47 is not satisfied in those cases. The first element in 47 is a wrongful interference with the actions of a third party in which the claimant has an economic interest. Now, there's no wrongful, in the licensee cases, there is no wrongful interference with the actions of RCA, the copyright owner, in which the licensee has an interest. So the licensee cases don't satisfy
the claimant has an economic interest.
Yeah.
Not the licensee.
Yes, well, the claimant is the licensee in the RCA case. It's not a claim by, it's not a claim by the Elvis estate, which owns the copyright. RCA is just the licensee, and Pollard is the bootlegger. The Elvis estate has granted RCA the exclusive license. By producing a bootleg album, the bootlegger is making the licensee's rights less valuable because he is selling competing products, but he is not, looking at 47A, interfering with the actions of the Elvis estate in which the claimant, RCA, has an economic interest. So these licensee cases don't satisfy the requirement under 47A.
The third party in the licensee case is a which then, for your purposes?
The third party in the licensee cases is the Elvis estate.
Elvis estate, and there's no unlawful action against...
Well, there is unlawful action, but it isn't unlawful action because it may well be a violation of their copyright. Yes. The bootlegging may be a violation of the Elvis estate's copyright, but it's not a wrongful interference with the action, looking at 47A, it's not a wrongful interference with the actions of a third party in which the claimant has an economic interest. Because it doesn't interfere with the Elvis estate's, the third party's, freedom to grant the licensee a license. And that's where the second sentence of 51 makes sense. That interference by the bootlegger may be unlawful as against the Elvis estate.
Does it not affect the... I mean, I don't know. I'd have to look at those cases more carefully. We may be taken to them. But in a sense, where there's a bootlegger, everybody, obviously the copyright owner suffers, but the licensee suffers as well. Why doesn't the licensee suffers?
Yes,
because
he does.
So everybody suffers.
Yes, he does suffer. But he doesn't suffer as a result of a wrongful interference with the actions of the third party, the copyright holder, in which the claimant has an economic interest, because the only relevant action of the third party in a licensee case is historic.
No, but
It's the grant of the license, which simply says, I'm going to grant you, RCA, a license. I'm not going to grant it to anyone else. Done deal.
But is that actually?
Yeah, that is the great ratio.
reality? Because if the licensee is an exclusive license, any sales by anybody will undermine his
Yes.
economic interests.
Yes.
And so anything which interferes with the exclusive right of the copyright owner to decide who should be entitled to get the goods interferes also, by virtue of that, with the licensee.
But, my lord, if you were to consider that RCA and Isaac Oren were wrongly decided, in a sense I would probably grab that with both hands, but within the framework of what Lord Hoffman was saying, they are rightly decided and they are being explained, because the only relevant actions of the third party in these licensee cases is the action of the third party, the Elvis estate, granting a license to the licensee.
Which,
Now,
as you say, is historic.
Which is historic.
So there's no current interference.
Exactly.
So what I'm not quite understanding is why it's not a good example of the principle which Lord Hoffman says in the second sentence of paragraph 51.
Yes, it is. The license cases are exactly explained by that second sentence. That is my point. That's why paragraph 52 starts with the word thus.
Yes.
It is
These are justifications for, as you would say, this new principle being introduced by Lord Hoffman.
Well, whether it's a new principle or whether it is simply a way of describing why the requirement in 47A isn't satisfied in that kind of case is another matter. I'm not sure, again, it's a matter of taste, whether I think we do say in the skeleton it's a new requirement. What it may in fact be is simply a way of describing, in relation to licensee cases such as RCA and Pollard and Isaac Oren, why the requirement that is in 47A isn't satisfied in those cases.
Your wider talk, Mr. Crowe, was the wider than just simply public authorities, was beginning to have a bit of attraction with me. Was that you do something wrong to a third party, unlawful to a third party, and that causes injury to the claimant, then you're within the bounds of the tort. I mean, here the bootlegger, as you say, commits a breach of the copyright, and that also is as much unlawful as anything else you've been talking
Yes, it is.
about. So why shouldn't that be within the tort?
Because it doesn't satisfy, we just need to be absolutely clear on what 47A is saying. It's not just a wrongful act against a third party. 47A requires a wrongful interference with the actions of a third party in which the claimant has an economic interest.
And that's creating a narrowness that you've just tried to rule out of the...
No, with respect. It is not that the actions, well, I'm taking two stages. What 47A is definitely saying is that the claimant has to have an economic interest in the actions of the third party which are interfered with. Now, the actions in our case of the third party are the grant of a patent. That is an action in which my clients have an interest. But in the licensee cases, the only relevant actions of the third party, the Elvis estate, in which the licensee has an interest, is the grant of the license to the licensee. And that grant of the license isn't being interfered with by bootlegging. The value of the license is being diminished, so the licensee suffers loss. there may also be a breach of copyright, so an actionable wrong may be done against the Elvis estate. But the wrong done is not an interference with the actions of the Elvis estate in which the licensee has an economic interest. It is a compendious requirement, that. So we do say that that 47A requirement does have to be satisfied, but the action, sorry, just going back, just to close off the points that my Lord Justice McComb just raised, there has to be a wrongful action, interference with the actions of a third party, but those actions do not necessarily have to involve a commercial dealing between the third party and the claimant, which is why cases such as a public authority case survives 47A. It simply talks about actions of a third party. The European Patent Office issues a patent. That is an action by it in which my client has an interest. The High Court grants an injunction to restrain competitors entering the market. That maintains between 2001 and 2007 inflated, uncompetitive drug prices. So the action by the High Court in granting an injunction is an action in which my client has an economic interest. So what we suggest, as I say, just to wrap it up, is that 47 up to the first sentence of 51 describes correctly the history and defines the tort. What the second sentence of 51 and the cases then discussed comprise is a description in the circumstances of those particular cases of why the requirement in 47A is not satisfied. But it is, with respect, impossible to read that second sentence in para 51 as a hard-edged requirement in all cases for the tort to be satisfied, because it simply cannot survive, either in terms of the history and the cases that have just been discussed, or the clear definition in 47 and in 61 that we saw, defining the tort without reference to a dealing requirement. Yes, his lordship was focusing on dealing because he was involved in a case involving dealing. So yes, he was thinking about that.
Well, except that Hello was not a case involving dealing, was it? Why it failed?
Well, it failed. Lord Nichols' very short answer to why it failed was that Hello had done nothing unlawful at all, because they didn't contract the paparazzi. They simply made it known, as if anybody needed telling, that if somebody took some illicit photographs of the wedding, they would pay. But Lord Nichols simply said, well, that's not an unlawful act. Lord Hoffman does say, it's quite true, Lord Hoffman does say, well, there wasn't an interference in the Douglases. He aligned the Douglas case with the RCA and Pollard case. He said there wasn't an interference between the Douglases, with OK's freedom to enter into an exclusive license, an exclusive photographic license with the Douglases. So he described it in those terms, and as I say, Lord Nichols says, well, there just wasn't any unlawfulness, so that the issue doesn't arise. But as I said, we do urge on you that there is nothing in the antecedents to OBG and Allen which supports this dealing requirement as a freestanding requirement in all unlawful means cases. And secondly, it is inconsistent with the express discussion and apparent approval of those earlier cases in this judgment.
As I said, Mr. Crowe, I'm sure at some stage you'll help us with what the other three judges said.
Yeah. No, absolutely.
How that fits in with your analysis.
Yeah.
For my own part, I'm finding that's worrying.
I'm grateful. Can we just finish with Lord Hoffman? So we get Pollard, Isegor and Lunro and Shell, which was an attempt to back a claim on criminal contract conduct. And then at para 56, Lord Hoffman says this: "Your Lordships were not referred to any authority in which the tort of causing loss by unlawful means has been extended beyond the description given by Lord Watson in Allen and Flood and Lord Lindley in Quinn and Leatham." Now, just pausing there, Lunro and Fired was self-evidently one of the cases to which their lordships were referred. So his lordship is saying in terms that Lunro and Fired does not extend the tort beyond the description given in Allen and Flood and Quinn and Leatham. And in our submission, that is right, because neither of those contain a dealing requirement, and Lunro is entirely consistent with the general description of the principle of the tort, which is based on an unlawful act by the defendant as against a third party, with the intention of causing, in fact, loss to the plaintiff. So that sentence at the beginning of para 56 is extremely important, knowing that Lunro and Fired is one of the cases they were referred to. And he goes on to say, not only has nothing been cited to extend beyond that description, nor do I think it should be. The common law has been traditionally reluctant to become involved in devising rules of fair competition, as is vividly illustrated by Mogul Steamship. Important thought in there. Again, it just illustrates his lordship was thinking about competitors suing each other and trying to use the law as a tool in competition, which is not what our case is about. We are not a generic drug manufacturer trying to sue Servier. We are a consumer, essentially, the largest single consumer in the UK of the drugs. So the concerns his lordship expressed of the common law's reluctance to become involved in devising rules of fair competition are simply not applicable here.
But if you're right, would a generic drug manufacturer, or indeed a private patient, not have the right to sue?
Only if they could prove the necessary intention to harm. And that, in relation to both an individual patient and the generic manufacturers, I'm not arguing the case, but it would be extremely difficult for them to prove, because and we'll see actually a subsequent case involving freight forwarding, Emerald Supplies, where a very similar question arises. In principle, there could be a claim, but you can't assume it would work, because it is a necessary element of the tort that there should be an intention to injure that plaintiff. Now,
not a series of plaintiffs.
Yeah, no, not the UK.
They intend to harm consumers.
I may or may not need Perindopril.
The fact that it's so large, you would infer intention.
So, I personally,
a single patient, you wouldn't. That seems slightly.
Well, no, with the greatest respect, because that's exactly how the questions on intention are decided, by reference to what the facts are. The facts are that the NHS, viewed it as a sort of single global entity, is inevitably not only a consumer, but the principal consumer of Perindopril. So it is the loss to the NHS is the necessary means for Servier to acquire the profit that it seeks by unlawfully extending its monopoly. We are the necessary means for achieving that outcome, and that is, actually if we've got this page open, we just look at para 62, sorry, I know I'm overrunning, but just closing off this point. Para 62 of Lord Hoffman, he talks about intention. He says, in the Lumley and Guy tort, there must be an intention to procure a breach of contract. In unlawful means tort, there must be an intention to cause loss. The ends which must have been intended are different. South Wales Miners shows that one may intend to procure a breach of contract without intending to cause loss. Likewise, one may intend to cause loss without intending to procure a breach of contract. But the concept of intention is in both cases the same. In both cases, it is necessary to distinguish between ends, means, and consequences. One intends to cause loss, even though it is the means by which one achieved the end of enriching ourselves. That's the NHS case. On the other hand, one is not liable for loss, which is neither a desired end, nor a means of attaining it, but merely a foreseeable consequence of one's actions. Causing loss to a potential generic manufacturer who might want to enter the market is likely to be a loss which is foreseeable, but doesn't satisfy the intention requirement.
These proceedings all arose out of an interlocutory injunction that was obtained, as I recall, against a potential generic drug maker.
Well, I'm not suggesting...
Those are the people they got the injunction.
No, absolutely. Well, sorry. I was answering my law's question, but the question was posed, does that mean an individual patient and generic drug manufacturers would have a cause of action? To which the answer is, in principle, they might, if they could prove the necessary intention. I'm not suggesting they couldn't. And an individual generic manufacturer who has in fact invested, manufactured and seeks to market this, and who is then restrained by injunction, may well have a good claim. I'm not saying he doesn't, but I certainly don't have to prove that he does.
No, I thought you were saying it would be very difficult for anybody else to do.
In the generality of cases, it would be.
What I'm putting to you is that's not true in a patent case. The whole point about enforcing a patent for a drug is to prevent generic manufacturers from undercutting. That's the whole point of why you enforce your patent.
Yes, absolutely. But the
generic there are more likely person you want to injure, I'd have thought, than the NHS.
Well, my lord, one cannot simply assert that all generic drug manufacturers will necessarily want to market and sell Perendopro.
No, of course not.
So, in particular factual circumstances, maybe one of them has a sufficiently well-developed business plan and capabilities to do so, and it can be shown to be known to Selvier, and in that situation, maybe yes, there would be a sufficient element of intention. But all I wanted to answer was to, and I'm sorry I've overrun, the two parts of the answer. One, in principle, yes, other consumers and generic manufacturers could, but the requirement for intention would have to be satisfied, and that's certainly not a given.
Thank you very much. Starting at 2:05. Surprise.